I'm muted. Charlie, can you hear us?
Yeah, I can hear you.
I can see you, but I can't see you. I must be doing something wrong. I can see you now.
I can see you.
You can see who's speaking, so when he spoke, you could see him.
Well, seems to me I just lost the. I gotta go back now.
I assume the courtroom can hear everything that we're saying too.
Well, I'm not on yet. I got out of it.
Oh, okay. That's all right. Now I can hear you on my phone.
Yeah, right.
Elizabeth, I'm Charlie Photo. Can you hear me?
Yes, I can hear you, Charlie. Nice to meet you.
Nice to meet you too.
Thank you for being here.
My pleasure.
Yeah, I don't.
There we go. So yeah, we can hear you here in the courtroom. We are having a technical issue with our ability to control the booths. So we are working on getting someone from IT into the courtroom so that we can manage the booths. So everyone should sit tight, and then we'll get going. Thank you. It's not a jail issue. Thank you, Lieutenant Barry. We're good from your end. And I just got your message. We will start with position 5, and then we'll do position 6. If we could save positions 1 and 2 for the end, those will be the longest. The others should be pretty quick, if that works for you all. And positions 7 and 8, that's down at Union City anyway. We do not need to see position 7 and 8 directly. We'll just do it with lawyers.
You're back, Howard.
Yeah, but I don't see you.
I see you.
Yeah.
Howard, press your button to the right on the.
Hey, how you doing, Mr. Steve?
Hi, Howard.
Oh my God.
Good, Howard.
So press what button to the right? The one on top?
There's a little arrow button that you
A
can.
blue arrow?
Yeah, blue arrow. Go back and forth, and you'll be able to see everybody online.
I see Liz. I don't see. No. And my daughter works for Zoom, and she's embarrassed that I'm a father because I can't navigate it.
That might not be the only reason.
Who said that? Judge? Who said that? The judge?
I think Mr. Byrne did.
Oh, thank you. Sliding blame.
You look good, Stephen. You staying healthy?
Okay.
Yes, thank you.
Yeah, good. Okay, well, that's what it is. I'm not there. I don't even see me. I see me. And now I see you, Charlie.
We see you pretty clearly, Mr. Weintraub. When you talk, you become front and center on the screen.
You may want to step back a couple inches, Mr. Weintraub. There you go. It's a little scary. There you go. There you go.
Mr. Byrne.
Yes, Judge.
It's my virgin journey.
How do you get into the, have you ever gotten into that controller screen?
That's why.
Well, you'll be able to go to one of these 10,000 trainings that they have. And then you'll know that, you know, I agree. I don't do it all that often. Does he know what courtroom we're in?
Yes, he's been here.
Okay. Hey. Doing well. Yeah, if you can come back here. So you can soup it up later, but here is how I have always gotten into the Zoom room controller. Long ago, we got an email back in May. So I download this guide, and then this link I used to click, and it would get me in there. It doesn't like that link anymore.
Yes, we are having issues with that.
So how do I get to the controller for, I have all the booths up and I need to mute them. I want to add them. They're in the call. So let me get this big again. I need to mute all these booths, but that means I need the controller to do that.
It will allow you to mute. Oh, wow. Normally you can have, if you have control, you can mute here.
Well, I'm the host. You know what? I'm not the, can you make me the host again?
Yeah. Yeah, if you're the host, you should be able to mute. If you go out there.
I was the host briefly because we put this on. But I do need a way to get to that page. All right, so.
You should be able to do
But
that.
can I unmute it? It won't work if I can't unmute it. Historically, yes, you can unmute it, but if you don't have this level of control, then you can't unmute it. And there's no one at the jail to unmute it. They're on the other side.
Okay, so let me check something here.
I'm sorry, sure.
Let's go to one of the ones we have here. And unmute.
Well, but that's here in the courtroom.
That, I'm not sure if we do that, if it's gonna allow you to unmute it.
What it will, like if I were to mute, one of the things here, I then have to ask them to unmute it. And there's no one at the jail side, but this control screen I used to be able to get, I could mute and unmute, I could turn the video on and off, and that's the screen I need to have pull up.
Yes. And that's what we're having problem. We have the last couple of days, I haven't been able to get to that screen that you're talking about. So I think what happened on the county side, they changed something in the network. And they had to back into it to allow it to come back.
Well, the booths don't work well. Then we can't hear any noise in any booth goes into the system. So we need to escalate this one.
Okay, I will do that. Can we do this? Let me take a picture of this bottom booth. And what I want to do is
They were saying something about mute or something.
Yeah, it's not on you. You're good. We're working on it from our end.
okay, so what I'm gonna do, let me mute this one.
If you mute that one, I can't use it, so don't mute that one. If someone shows up in 7 South, I won't be able to use it.
So let me do this. Let me go to my office and see if I can get to that link, and I'll email you the link.
Great,
Okay.
that would be super. We're gonna get started. Audio is gonna be poor because we can't mute all the other booths. So I'm gonna ask you, if you're in a booth, to be extra quiet unless you are up and running. I apologize for that, but things aren't working well with IT over here. So we're gonna start. We should have is Mr. Harris there, Tori Harris. If you're there, say good morning. You're kidding. Brianne is muted, you're right. All right, how about Carlton Gibbs?
I'm here.
Fantastic. We're gonna work with you, Mr. Gibbs. Ms. Wood, you on the call?
Good morning, Judge.
Good morning. So I believe Mr. Gibbs is on for plea and arraignment. It doesn't say on the calendar, but I think that's what he's here for. Is that your understanding, Ms. Wood?
Yes, Judge, we will waive arraignment and plead not guilty today. We are working on a placement for Mr. Gibbs.
Okay. So, Mr. Gibbs, you're charged with robbery in your case, and Ms. Wood, your lawyer, is going to fill out some paperwork on your behalf. And then she will be able to get with you, share with you the evidence that the state has, and we'll figure out what we're going to do next with your case, okay?
Okay.
Do you have any questions for me?
I don't.
All right. Well, Ms. Wood will be in touch with you soon once she gets discovery from the state, and we'll go from there. Ms. Hall, anything on Mr. Gibbs' case? All right, Mr. Gibbs, it's nice meeting you, and we'll see you over here sometime soon.
Okay. Do you know how long will it take?
So how long will what take?
Like,
Mr. Gibbs,
huh?
I'm gonna come see you next week, okay? And we'll go over everything,
Okay.
okay?
So Ms. Wood will be there next week. She'll talk to you about a placement, resolving your case, et cetera, and then she can help you understand what the timeline's going to be, okay?
Okay.
All right, thank you, Mr. Gibbs.
Yeah.
All right, I think we have Mr. Stokes. Mr. Stokes, are you there?
I am.
All right, can you hear me?
Can.
Are you in 3 South?
I am.
Got it. Okay, Mr. Stokes is here and Mr. Sharp is here.
Correct, Your Honor. Let me come to the table.
To the podium or the table, either microphone, so your client can hear you. Ms. Hall, are you handling this matter?
I am, you are.
All right. Ms. Rivers, are you ready to take this down?
Yes, I'm on the record, Judge.
Fantastic. Good morning. So this is position 3, state versus Mr. Stokes, 08SC 67047. It's an old case. Mr. Stokes is on probation or was on probation at some point, and I have a petition indicating he violated his probation. They're technical violations that I have that he didn't report and he hasn't paid. Mr. Stokes, are you able to hear us?
I am,
Good. All right. So tell me, Mr. Sharp, what you're thinking we're going to do today with Mr. Stokes.
So, Your Honor, I believe that he has new charges. There should be new charges. I don't know if that's.
There is a pending case. I've got that case number. It is not a basis for his revocation.
Okay.
The petition I have is just the technicals. That's not to say there isn't a petition rattling around out there with the new charges, but all I've got to work with are the technicals.
We're fine to go forward with just the technicals, Your Honor.
Okay.
What's before us. And so what we're going to be asking for is that my client be reinstated on probation on this matter. My client has, bear with me. My client is 41 years old. He's been in custody since April the 11th of this year. So he's been in custody roughly about 4 months, a little bit more than 4 months on this matter. Can I just pull my, or
Sure. When you're talking, it's fine if you have your mask down.
And so if he's to be reinstated, he's staying with his fiance. Her name is Elena Smith, and that address would be 3144 Reeves. That's Reeves Circle, apartment 145. That's here in Atlanta, Georgia, 30311. He does have a job, and that job would still be available to him. He'd be working at a studio. He's a music producer and manager, and he'd still be that would still be available to him. That work is also here in Atlanta at 1740 DeFore Place. My client has 3 children that he takes care of, a 16-year-old little girl named Amaya, 2 boys, Marcus and Mikkel. And so what we're asking, Your Honor, is due to the lengthy time that my client's already been in custody on this matter, that he be reinstated back to probation.
So I'll hear from Ms. Hall in a minute. I'm looking at the unindicted charges, which are not a basis for the revocation. I'm just understanding Mr. Stokes' situation. He has a $19,500 good bond that he needs to post. Just recently, a judge denied a motion, perhaps yours, to modify or reduce that bond. Doesn't look like Mr. Stokes has posted the $19,000 bond, but you're asking that we do something that basically gets this warrant out of the way so that if and when he can make the bond in the unindicted case, he'll be able to go live at the address you mentioned and work at the job you described.
That is correct, Your Honor. That's exactly what we're asking for. And I do believe that Mr. Stokes would be able to make the bond. Even if the judge would have lowered it, I don't know if Mr. Stokes would have bonded out, just simply because while he's in custody, we want him to build up credit for anything that while he's in custody. So that's the reason why he hasn't bonded out.
Okay. Good morning, Ms. Crawford. Could you tell me how much time Mr. Stokes has remaining on his probation?
Good morning, Judge McBurney. Mr. Stokes has 4 years, 11 months, and 20 days remaining.
Okay. And is this the only case that is open and active that is on probation?
This is the only case open in Fulton County. He has another case in Bartow County.
Okay. Well, we can't do anything with that one. Thank you. Ms. Hall, tell me what the state's recommendation is. It sounds like, Mr. Sharp, I guess before I shift to Ms. Hall, that your client is admitting that he failed to report and that he's failed to pay. But you're admitting to the technical violations.
That is correct, Your Honor.
Okay. The address you gave, I didn't write it all down, but it was Reeves Circle. Is it the address that the officer tried to visit him at? Because we'll need to understand why that didn't work. It was a while ago. This is an old, this petition and warrant caught up with Mr. Stokes, or it may be that the new charges caught up with him, and then that's how this warrant got served.
And so the address is been his address since I've been involved with this case.
Okay.
As it pertains to, 2 years ago, that I don't know.
Okay.
But I know that Ms. Smith, who's the person who I've been in contact with, who paid my retainer, has, that's her address.
Okay. Ms. Hall.
Good morning, Your Honor, again. The state doesn't have an objection to the defendant being revoked on the time that he served so far and continue him on probation. I have spoken with Ms. Crawford about getting a different petition out for the actual CP case that has those more serious charges on those.
Okay. Got it. Mr. Stokes, have you been able to follow what your lawyer was saying and what the prosecutor said?
Yeah, Your Honor.
So it sounds like a while ago, it would have been February of last year, probation had trouble finding you. That should never be the situation. You need to be easy to find. It also sounds like you haven't been paying restitution, but I heard you're making money working at a recording studio. You're going to need to pay the restitution that you owe on this old case. It's not a small number, but you're able to make small payments. So you're going to need to stay current on that. I find that you did violate the terms and conditions of your probation by being hard to find, basically failing to report, and that you have failed to pay. I'm going to revoke 90 days of your probation. I'm going to give you credit for the time you've already served, which is more than 90 days. So you've served your revocation for this petition. You may have heard Ms. Hall, the prosecutor, mention that there may be another petition coming down the pike that is related to your new charges. We'll see if that happens or not. But this warrant, at least, will go away, and you'll be in a position to try to post the bond on your new charges. Does that make sense, what I just described?
Yes, it did, Your Honor.
Any questions?
Only question I have, so that mean I can make bond?
Sure. I mean, you could have made bond 3 months ago. You wouldn't have been able to get out because of this warrant. But this warrant in the next day or so will be lifted. And then if you post bond, in theory, you'll be released. I don't know if there's a hold from Bartow County. Your lawyer, Mr. Sharp, is saying there's not. So it does sound like if you post bond early next week, you ought to be able to be released.
All right, thank you, Your Honor. The question that I have, can y'all at least give my lawyer, my probation information so that I know who I need to get in contact with if I apparently do to make a bond?
So I'm going to ask Ms. Crawford what she, if she has anything about reporting.
Yes, Judge. Since he has a bond to make, I'm going to suggest that you report to probation 48 hours after your release. I'm not going to give you a specific date because we don't know when you're going to make bond, but you do know where the probation office is, don't you?
That's the one across from pretrial. That's across from pretrial, right?
That's correct. Your officer is Officer Everett, and you just need to report there between 48 hours after your release, between the hours of 9 and 12 to your probation officer. And I'll put notes in there.
Thank you.
You're welcome.
All right, so what you'll want to do, Mr. Stokes, if you have questions, is be in touch with Mr. Sharp, and Mr. Sharp will remind you of where you need to be and when, okay?
All right, thank you.
All right, Mr. Sharp, anything else on behalf of Mr. Stokes?
No, Your Honor, and that's all I have. May I also be excused?
You may.
Do you need our signature? If you do, we give express permission to sign any document.
Nothing. Only thing is I need to sign, not you all. So you're free to go. And Mr. Stokes, you are free to go as well. Thank you.
Thank you, sir.
All right. I think Mr. Harris is now here. Well, he may still be muted. Mr. Harris, can you hear me? Yeah, if he's in 3 North. The machine in 3 North is muted, and the big problem we've got here is the controller that I normally can use to mute and unmute and keep people quiet. It's not working. So unless someone can get to the attorney side of the booth in 3 North, we need to move Mr. Harris somewhere else. We've already flagged this as an issue, and IT is working on it. But for now, we're stuck. 3 North, I can't turn the volume on. Let me see if we've got anyone else. Do we have Mr. Salmeron? That's position 4.
Sir,
Yes.
I need interpreter. I don't speak English. I speak Spanish.
Okay, well, we'll work on that. No one told us that we would need that. We worked with a relative of yours yesterday and they declined to tell us that. So we will get an interpreter, okay?
Yes, I need it. I need it.
Got it. Who is representing Mr. Salmeron?
Uh,
I believe the entry says Kenya Bryant from the Conflict Defender's Office.
Yep, so I was wondering if there was anyone from the conflict defender on the call. All right, so we'll work on getting an interpreter and we'll work on getting the conflict defender to show up for the calendar. So Mr. Harris, position 5, we need to get into a different booth. What about Ms. Brown? Is Shamal Patel, she's on this call. Ms. Patel, you there? We may be able to unmute 3 North right now. Someone just stepped in. Anyway, Shamal Patel, can you hear me? What a day. All right. You're working on getting an interpreter? Thank you. Patel is there, but her microphone is not working. Join the club. Technical issues.
Your Honor, can you hear me?
Yes, I can.
Perfect.
Good morning.
Good morning.
So let's talk briefly about Ms. Brown. She's got 2 positions on the calendar. She's not joining us today by design. I remember her situation, and some organization bonded her out, which was well-meaning, but maybe not what she needed most. And we need to figure out what's happening next. Ms. Hall stood up, though. Maybe she has an announcement.
I do, Your Honor. So the state will be no processing both of her cases. So this is the state, to give you context or our reason why we have been dealing with this case for over a year, coming back and forth to court. Ms. Patel has been trying to get her into some type of placement, as you already know. But then she also has the option to go home to her mom, who lives in Ohio. We felt as though that no prosecution, she has already served 351 days in the time in which she's been coming in out of the.
For shoplifting and an entering auto.
Where the entering auto, nothing was taken, she was sleeping in the car, she didn't get to take a change, and then the shoplifting, the items were returned. So the state feels as though she's actually served her punishment or would have gotten something even less, maybe probation, rather than almost a year of time in jail. So we made the decision to no prosecute. Ms. Patel will still work in trying to get her home to her mom because I'll let her tell you her situation, but she has other things going on now that
Ms. Brown or her mom?
Ms. Brown.
Okay.
And so we just would like to make it easier for her to get back with family and deal with the things that she deals with now.
Okay, Ms. Patel, I do want to hear from you, and maybe you can weave into it the timing of doing this, because I may hold off on signing the null process until we know that there is a mechanism for Ms. Brown to get to Ohio. Otherwise, I fear we'll be repeating what Marilyn Wynn and her organization did, which was to spring Ms. Brown, and then unfortunately for Ms. Brown, she'll be back on the street, and that doesn't always end well.
We did speak about that as well, Your Honor. This was something that happened yesterday afternoon, so I don't think Ms. Patel has been able to make that contact with her mom. But she also was trying to find housing for her here as well, because that was an option for her. I just thought that it would be better we don't want her to really be released from Georgia medical, but I think that it'd be easier for them to help her maneuver around if we let go of the case. And she started what she should start for what we think she should.
Got it. Ms. Patel?
That's correct, Your Honor. I was told last night or yesterday afternoon about the state's decision. So I had my social worker reach out to the Georgia Regional Social Worker because I know that they've been looking for places. I am not sure how long it'll take for them to get back to me on housing. Our bigger concern is that she's due to have a baby in September. So we're trying to get her out as soon as possible, in large part so that her child isn't put into foster care, as that would be the situation if she remains at Georgia Regional. With that being said, I had confirmed with the mother that she's open to having Miss Brown come up there and stay with them. It'd just be a matter of logistics. And alternatively, we're looking into some temporary housing in Atlanta so that if we can't quite get her to Ohio immediately, we can at least find a temporary place for her here.
Okay. Boy, I wish the best for this child. Tell me about timing. I don't know when Ms. Hall is going to be able to get us the null pros orders, but I can hold on to them until you tell me you've lined something up for Ms. Brown. What's your preference?
So as an advocate for my client would like to be released as soon as possible. Now, if Your Honor had decided to hold on to the orders, that would be Your Honor's decision. But I know my client has expressed that she wants to be out ASAP no matter what, even if we don't have housing and set up.
And what is your client's plan for staying somewhere as she works on the pregnancy?
Her plan would be to try to get back to Ohio. Now, whether or not she has the practical means, I'm not too sure about. But I know that her preference is that there isn't a delay in the signing of the orders. However, your honor, delays the signing of the orders, then that's not in my hands.
Would your team continue to look for a housing option for Ms. Brown, or given the state's announcement, you're redirecting resources?
We're not redirecting resources. We are trying to, I basically sent out an emergency email to my supervisor of the social workers as well as my social worker, and she said she would try to get on top of it today and see what we can come up with.
Okay. Well, why don't we do this? I don't have anything to sign right now. When I get it, I'll have Ms. Nelson let everyone know that the orders are available to be signed. And I may want to get an update from you, Ms. Patel, about look, if within 3 days we think we'll find something, I may choose, exercising my discretion, to withhold signing them for a few days. If the housing falls through, I'm not going to wait indefinitely, but we've been through this cycle with Ms. Brown now 3 times where she gets out and it doesn't go well. And now there's another person involved, if you will. So, okay. All right. Thank you for that. Ms. Hall, when you get a chance, no rush, get those orders to Ms. Nelson.
I will.
We're going to take a technical pause. I need to send an email about folks trying to help us with the controller.
Judge, this is Isaac. I'm on the call.
Fantastic. I can't get to the controller. That's the issue. The controllers probably work, but we cannot get to the controllers. The link we used to have to get to the controllers is a dead link now. It says it's not secure. And so I just can't get to that screen you designed that lists all the booths.
You're in your courtroom?
Yes, sir.
I'll come down there if that's okay.
That would be fantastic. Thank you.
I'll see you in just a minute.
All right.
And Your Honor, may I be excused? That concludes my matters.
Yes, ma'am. Thank you for your help with Ms. Brown.
Thank you, Judge.
Yeah, well, so Isaac is able to get into it. I just need to get into it. I know how to use it. We can't get to it. Yeah, so he sent an email saying, hey, here's how you mute. I know how to mute. I need the button. All right. So we have positions 1 and 2 left. Intentionally, we're holding off on those because they're going to take a minute. We're trying to get Mr. Harris, who was in very much the right place. The jail put him in the right place, which was 3 North. But then we couldn't unmute it. So we still need to figure out how to get to Mr. Harris, and we're working on getting an interpreter for Mr. Salmeron. So, sit tight.
So, Judge, do you need position 2?
Almost, not quite yet, please.
Okay, so position 6, he got reset?
6 is all done. We're done with 6. We're done with 7. Well, you didn't have 7 and 8. All we got left are 1, 2, 4, and 5. That's it. And 4, we're waiting on an interpreter. And 5, we have a technical issue. We can't unmute the microphone. You can come on back here if you want. I think you gotta go around that one.
So do you know when you're gonna be ready for position 2? I can drop down to 5 South and put him in the booth.
You can bring position 2 in, but it'll be a minute. We're gonna have a bond hearing on position 1. So you probably got 15 minutes.
Okay, thank you.
Sure. Oh, you can go around this way. It'll be easier because then you can go back. And I did a bad job of communicating the issue. I can't get to the controllers. I know what the controllers do, but I can't get to them. The link that used to work doesn't work anymore.
Judge, can you log into your?
Sure. Yeah.
Chambers account.
Yeah. Yeah. Oh, but I have to do the password. I don't remember it. Let's see. Yeah, and then. Oh, that's not it. It autofills, so I forgot it. No, that's not it. Deidre will know what it is. It's,
I need to make. I will log into mine real quick. Make some changes. Sorry.
no problem. I had been using there's a link in a PowerPoint type document you made, and just I could click on that and I'd get in there, but didn't.
Yes, we have an issue with that link with the ISP.
Yeah, well, didn't know that. So Judge Eaton, this is real life. It's good that you're seeing this. These things happen. But then these smart people arrive and they try to fix it.
Studying up on the rules of evidence, I need to study the rules of Zoom.
Yeah. So you can tell us the password.
Okay.
Can you write down the password to the Zoom account? Oh, okay, I can do that. I didn't capitalize my name.
Oh, okay.
It's all right. So this I've been able to, oh no, that's how, it has all the booths now.
Yeah, so we can launch from here.
Yeah, that's fine. I can do this. But before the booths didn't show up, it was just prices in here.
That's because I just gave you access to the jail.
Okay, but this is different from what Isaac built. Isaac had a different screen,
Yeah, we built that and.
or whoever built it.
So they're talking about.
There's one where it was dark blue and you could click north, south, or booth one or
Yeah,
two.
we
Something.
built that one.
That's where I used to go with that link
gonna
that's
work.
dead.
We're working on that.
Okay. Okay. All right. So this will work. So now I can, well, let me, before you leave, let me make sure. So like 1 north, I launch the controller. And if I,
It's not to the call. If you go back.
Oh no, why is it not in the
You
call?
need to, so this one for the call is red. This one is not.
Because that's booth 2. It shouldn't be. Good. Booth 2 shouldn't be. So let me launch the controller. All right. So I can mute 1 north. Good. All right. Now I can do good. We can get the guy in 3 north on now. Okay. Fantastic. But we're going to need to.
Fix that link today.
Good. All right. Thank you. So where is 3? Is it 3 north we're trying to get into? Yes, 3 north. Unmute. There we go. Hey, Mr. Harris, can you hear me?
Yeah, how you doing?
I'm doing well. Thank you for your patience.
Yeah.
We have been doing our best to get everyone connected here, and it hasn't worked so well. I'm muting all these other booths so we get less feedback. 7 north. All right, everything else should be muted except for yours. All right, Mr. Harris and Ms. Wood, you on the call still?
Yes, Judge.
Fantastic. Thank you for your patience as well. So, Mr. Harris, this should be short and sweet. I think today is your plea and arraignment date. You've been indicted for obstruction of an officer and criminal trespass. Ms. Wood is your attorney, and she's going to let me know if you are waiving arraignment or if you want to be formally arraigned, and then I'll let you know what happens after that, okay?
Okay.
Ms. Wood?
Thank you, Judge. Actually, Mr. Harris is waiting on restoration. I went ahead and prepared a 90-day order and I sent it to Ms. Nelson this morning. So yeah, I just wanted to let you know.
When you say waiting on restoration, oh, got it. Okay, so we ought to be on hold for a little bit until we get an affirmative report.
Yes, Judge.
Okay, so Mr. Harris, I missed a piece about your case. You had a good interview with some folks a while ago, and it sounds like you're working with the staff at the jail. And when they've done a little more work with you, then you and Ms. Wood and I will talk again, okay?
Okay.
Do you have any questions for me?
No.
Okay, well, Mr. Harris, it's nice to meet you. Again, I'm Judge McBurney. And Ms. Wood, I guess you and I will both get a report when something has changed?
Yes. Judge.
Okay.
Okay, fantastic. All right, thank you, Mr. Harris.
Thank you.
Thank you, Judge.
Yep. It took me a minute to understand, like, is that a placement you're trying to get? But then I got it.
Thank you.
I'm thrown by these technical issues. All right. So we should have remaining, we need to arraign Mr. Salmeron when we get we have Ms. Mendez. Good morning, Ms. Mendez.
Good morning, Your Honor. How are you?
It's great to see you. I haven't seen you in a long time.
No, it's great to see you. Thank you.
Let me get Mr. Salmeron back on. He is in 7 North. Give me a moment, please.
Yes, Your Honor. Also, if somebody could provide me with the case number and the name, because all I had was how to get in this Zoom meeting.
Sure. I'll let Ms. Nelson do that while I'm working on 7 North.
Hey, Your Honor, that concludes my business. Will I be excused?
Sure. I guess because Ms. Patel has Mr. Salmeron's case. Got it. Okay. Yes, ma'am. Thank you. But I'll see you this afternoon.
See you this afternoon.
Great. Oh, you know what? We don't have a lawyer for Mr. Salmeron. Did anyone from the conflict defender's office show up? Nope. We'll work on that. Ms. Mendez, did you get that info or do you want me to share it with you?
Yeah, if you could share it with me, Your Honor. If it's easier to just place it on the chat, that would be fine.
Okay, I'll let Ms. Nelson do that. And I think what we'll do, we're going to need to, she can share that information with you. We may move you and Mr. Salmeron into a breakout room so that you can introduce yourself and explain to him what's happening with the arraignment. Hold on 1 second.
I went everywhere you were not.
Oh, I'm sorry. I should have said 8D. Dejuan made it up here. I'm in the controllers, but in the classical Zoom sense, that white screen. I can't get to that blue screen you built that has all the booths.
Could I see real quick what you see when you try to do that?
Yeah, you just come on around. So, Mr. Salmeron, we have an interpreter, and I'm going to have the interpreter talk to you a little bit, but we're still waiting on getting your lawyer. So
Señor Salmeron, tenemos al intérprete, señor Salmeron. Voy a dejar que hable con el intérprete en lo que estamos esperando al abogado.
So I click here, you go to this link. I used to get a slightly different message that said, this isn't secure. And
Please forward me that or whatever you're pulling up there. Was it a saved email on the
Yeah.
desktop? Could you attach that to an email and send it to me?
Yeah.
All right, and I'll reply with something.
No problem. And apparently Dejuan knows it's an issue too. He came in and now here's how I'm just using, this is how I'm getting into the controllers is through this.
Right, which is fine.
It's fine. It's
The other
just,
thing
yours
is
is
kind of a
easier.
short-
Yeah, but it's easier to, because you have to scroll through a million here and it's multiple screens. It works though, but it lists all of them. And so I have to make sure I'm using the red ones.
I have made one, and then I think Dejuan had Celia make another one, so I'm not sure if the one you're.
Which
gonna
one
use-
crashed? Okay.
I'm gonna make sure mine's still up, and I'll
Good.
give you that.
Good.
You can
I'll
use
take
it.
both.
Yeah.
Excellent. So that was my email wasn't clear. It wasn't that I could get to the controller. I couldn't get to the controller. That's the issue. But he backdoored me here, but we need for future judges, because we're going live on the 13th, a fairly foolproof, click here dummy, and then you get to the controllers for all the booths.
Okay, I'll work with the Dejuan.
Okay.
Yep.
Problem solved for today though. Thank you.
Sir, have a good day.
You too. All right, Ms. Mendez, I'm going to move you to a breakout room with Mr. Salmeron, simply just to explain to him what's happening today. You're not his lawyer. He knows that. We are trying to get his lawyer on the call.
Yes, Your Honor, I'll tell him we're here for arraignment.
Did you get the case information?
I sure did. Thank you.
Great, okay. Great.
If anything happens, just let me know. I can come right back over. I'm next door. Thank you.
And booth 7. That's interesting. It won't let me move that booth. Okay. Well, par for the course, it's not letting me move, I can move some of the booths, but not all of them. And Mr. Salmeron is not in a booth I can move. So what I'm going to ask Ms. Mendez, if you don't mind just sitting tight, you can go mute, and Mr. Salmeron's got nowhere to go. We're trying to find his lawyer. When we do, we'll pause our other proceeding and pivot back and take care of his arraignment, okay? If you could explain that to him, and then I'll mute you both.
Thank you. Señor Salmeron, me acaba de decir el señor juez que estamos esperando a su abogado, entonces no nos puede poner en una sala separada para que yo le explicara para qué estamos aquí. O es la lectura de cargos. Vamos a esperar a que llegue el abogado. Mientras tanto, nos va a poner en mudo hasta que llegue esa persona y ya entonces podrá usted comunicarse por medio del abogado. ¿Está bien?
Sí,
okay.
Está muy bien, gracias.
Okay, that's fine. Thank you very much.
Okay, let us turn then to position 1. That's Mr. Thomas. The cell number I don't understand. Is Mr. Thomas there?
I don't see him, Your Honor.
No, his cell number starts with an M rather than a number. Let me see. Lieutenant Barry? Well, that's medical. Okay. So if someone from the jail could let me know, we can do position 1 or 2 next. I don't know what we're doing with position 1 in terms of getting him to a screen.
Your Honor, this is Howard Weintraub. Can you hear me, sir?
I can hear you and see you.
I'm privileged to appear with you today. Thank you.
You're very welcome. It's mutual.
Yes, sir. Different times.
Your Honor, is Mr. Munson, this is Stephen Byrne, is Mr. Munson in a booth yet? I don't.
He's not. They asked when they should get position 2 in a booth, and I said they had a few minutes because I thought we were going to handle position 1 first. But I didn't realize that Mr. Thomas, that's position 1, is in the medical unit, and that is an area where we don't have booths. So I need the jail to tell me what the plan is getting Mr. Thomas to a booth. But I'm not, currently no one from the jail is responding. Here we go. Up, position 1 ready in medical now. Okay, where, well, what booth is that? So I know what to turn on. Because there's not an M booth. Is there a floor and a tower for medical?
Usually third floor.
Third floor. Okay. So it's either going to be 3 south or 3 north?
Definitely has its own section in the jail.
But is it in south or north, or there's like a secret third tower?
3 south, 3 north, and then Milton was on like another side.
Okay. We'll see what happens. They are getting Mr. Thomas ready. I don't know what that means in terms of connecting with him, but sit tight.
Position number 1.
Fantastic. Thank you. Oh, that's what the Fulton entry was. Interesting. Okay. Mr. Thomas, can you hear me? Whoops, you're muted. Can we unmute? Medical, can you unmute? Great, thank you. Mr. Thomas, can you hear me? Well, we cannot hear you. Say something louder.
Good morning, sir.
There we go. That's good. All right, we're going to go on the record in position 1, which is 14 SC 124579. It's Tyler Thomas, charged with murder. Mr. Thomas's conviction was reversed, so we are back in not quite square one, but we need to figure out what's next. And I believe today is to hear a bond motion from Mr. Thomas's team. Is that what's happening, Ms. Brandenburg?
Yes, Your Honor.
Okay. Mr. Abate, you are the only prosecutor left in the room, but there are some people on the call. Are you handling Mr. Thomas's matter, or is Ms. Beza?
I am, Your Honor.
Well, good morning.
Good morning, Judge.
All right. Mr. Thomas, I will hear from your lawyers and others. There seem to be a number of folks on this call. I will also hear from the prosecutor. It may be that I hear from the victim's family in this case, or an advocate for them. And there may be something you want to add. After I've heard from everyone, I'll let you know what my thoughts are about you and bond in this case, okay? All right. Ms. Brandenburg or Mr. Weintraub, however you want to proceed, now's the time.
Thank you, sir. I would like, with the court's permission, to proceed first, and then if Ms. Brandenburg wants to add some things to my comments, I would appreciate it if you would allow her to do so.
Sure.
Your Honor, I do want to state at the beginning of the proceeding that, as I noted in the last court proceeding, we are intending to call Mr. Abadi as a witness, and if this were a trial today, certainly we would have a problem of him acting as an attorney during the proceeding as well as a witness, and that couldn't happen. So I don't have a problem. I don't think Ms. Brandenburg has a problem with Mr. Abadi handling the proceeding today, Your Honor, but I would like the record to reflect that in no way is defendant Thomas waiving any conflict that would arise during motion hearings or whatever obviously during the trial itself, should Mr. Abadi be handling the case, because we are, unless the court precludes us, we're definitely calling him as a witness. So with that said, Your Honor, can I proceed, or do you want to address?
You may. No, I will make clear for the record that your concern is renewed and noted. I agree with part of your analysis, which is that I don't believe it's an issue for Mr. Abate to represent the state of Georgia for purposes of the bond hearing, unless you are going to be calling him as a witness in the bond hearing, and it doesn't sound like that's what you intend to do. But I'll be mindful as this case moves forward, regardless of your client's bond status, that there could be brewing a scenario in which Mr. Abate would be witness rather than advocate for one side. We're not there yet, so I appreciate you keeping that on my radar, and we'll certainly work through whatever issues that might create when we get to that point. But I think it is, I'm comfortable with Mr. Abate representing the state where we are in the process now. So you may proceed.
Thank you, sir. I would like also to state, Your Honor, that you do not see members of Tyler Thomas's family in the courtroom. I have asked his father to appear on, through YouTube. His father had quintuple 5 bypass surgery in March, recovering fairly well. Did not want him exposing himself to the Delta variant, and we spoke to some doctors and they agreed, and we appreciate you allowing him to appear through YouTube, but he certainly wanted to be here in support of his son, but we didn't want to do that. Also, Your Honor, emotionally, the defendant, his father, the team is, I'm having problems in that Tyler's older brother unexpectedly died Tuesday, 2 days ago, from an apparent overdose of what prescription pills or whatever it would be. And so his brother's funeral, I think, would be maybe next week. And so we have that emotional burden that the family is dealing with, as well as the anticipation of hoping we can have Tyler Thomas released on bond. Your Honor, Ms. Brandenburg and I were not the trial attorneys. We came on board in May 2017, maybe a little bit after that, Your Honor, for the post-conviction work. And it's my understanding, Your Honor, well, Tyler Thomas was arrested November 13 of 2013 in Carroll County on the warrant out of this case. Indicted in February of 2014. I'm not certain, Your Honor, when the first bond motion was filed, but it was denied. And maybe Ms. Brandenburg or Mr. Abadi would correct me, but I think Judge Newkirk may have handled that bond proceeding. Another motion was filed by his team, Eddie Garland, and the partners in his office filed a second motion for bond on May the 5th, 2015. That bond motion, excuse me, Your Honor, was heard by Judge Markle. And on June 9, 2015, the Honorable Judge Markle issued an order for bond, a $75,000 good bond with conditions, primarily a home confinement except for some limited circumstances that would allow him to leave the home. The home was going to be his father's home in Carroll County. that they've had since the 1990s, and wearing a monitoring device. He had a hold on him after the bond order was issued. Took Carroll County a little bit of time to pick him up. The hold was predicated on when Tyler Thomas was stopped and arrested in the vehicle. There was some drugs in the vehicle, and I believe that there were. I don't really know, Your Honor, what happened to the Carroll County case, but they held him. They had a hold on him, picked him up from Fulton, brought him to Carroll County. And on or about August 1st, A&A, All County Monitoring, and I have Charles Flauto here today, Your Honor, on Zoom, and we will call him in a couple of minutes to give some information to you. But they installed their A&A installed a GPS house arrest monitor on Tyler Thomas on August 1, 2015. We have submitted to the court, Your Honor, 5 exhibits, and had Mr. Abadi hopefully, receive that by email as well. And this would be exhibit number 1, Your Honor, which is a letter written by Charles Flauto, a compliance letter that shows that they had Tyler Thomas under supervision for 669 days. I think that may be a little bit off by 18 days because, well, maybe a little bit more, because technically when the bracelet came on, he was sitting in Carroll County Jail. And then when the verdict in the first trial came back on May the 12th, Tyler was taken into custody, and I think the bracelet may have remained on him for a couple of days. So he was under supervision, Your Honor, for well over 600 days. Mr. Flauto will tell you that he's monitored maybe 10,000, 11,000 enrollees in their supervised program. Tyler Thomas is in the top 1% of compliant, responsible, totally no problems at all. There were 4.
Just so I'm clear, and we may not need to call Mr. Flauto as a witness, I leave that up to you, and it may be that Mr. Abate doesn't contest the fact that while Mr. Thomas was on bond, he did not violate the conditions of his bond. But when you share with me that Mr. Flauto believes that Mr. Thomas was in the top 1%, my understanding of what Mr. Flauto's company does is it simply lets you know, is the person staying where he's supposed to stay? If he's supposed to be at home or church or work, the monitor tells them that. So this notion that there would be gradations of this guy was good, this guy wasn't so good. Mr. Flauto and his team didn't spend time with Mr. Thomas saying, hey, he's a stand-up guy, he treats his kids well, he drinks his milk, he doesn't smoke. He doesn't have any visibility into that at all. He simply could say he was where he was supposed to be when he was supposed to be there, which is not unimportant. I'm not minimizing that, but I don't want to maximize it either, unless I'm misunderstanding the nature of Mr. Flauto's business. It's not video cameras ensuring that Mr. Thomas isn't watching cartoons, but instead bettering himself. It's simply letting us know, is he staying where he needs to be?
Well, with that said, Your Honor, there was not one tamper violation with the equipment, although it says in the letter 4 instances of strap tampering violations: August 18, October 10, and October 15 of 2015, October 6, 2016, all of which events were not tampering by Tyler Thomas. They were equipment failures. They came in immediately when directed by him. He came in with his father. Father drove him to Gwinnett County in Lawrenceville. They had the equipment replaced. In fact, they had so many problems with the equipment that they had written in the letter that in 2015, they changed vendors, but Mr. Floto advised me today that it was actually in December of 2016. But to have a company monitor some 10,000 or 11,000 people, and he's in the top 1 or 2% of being totally compliant with every curfew, every whereabouts, every time they needed to be in contact with him regarding anything, I think is, and I'll move on, Your Honor, but I think is an important factor for us to consider, for the court respectfully to consider when determining if a bond should be again granted to Mr. Thomas. This history, Your Honor, well, if I can, Your Honor, Mr. Floto, if you don't mind.
Judge, I'll stipulate that everything in the letter that Mr. Floto said is true and factual and don't contest it.
Okay.
Is there anything else, Mr. Floto, that you would like to tell Mr. McBurney, irrespective of the stipulation that could cause, that could assist the court in determining whether a bond would be appropriate regarding the person that you monitored in Tyler Thomas?
Good morning, Judge McBurney. It's been a long time.
It has.
But in 2018, I believe. The only thing I would like to bring up is that through no fault of Mr. Thomas's, we at the time were having considerable hardware failures from the vendor we had at that point in time. And because a strap tamper usually would initiate us immediately to contact the sheriff's office, or in some cases pre-trial, because the strap tamper means somebody's running, and we react to that almost immediately. And if there's a bond company involved, we'll get bounty hunters running. It turns out that we were having false tampers, and not only with Mr. Thomas, but with many other people from this vendor. And Mr. Thomas, 100% of the time of those 4 tampers, we would call him, he would take a photograph of the device, we would send somebody out there, and it turns out it was on his ankle and it was fine. And that happened 4 times. And he responded immediately. One time he was at work, or at least twice he was at work, and a couple times he was home. So the only issue is that unfortunately, we don't get that kind of immediate response from the bulk of our installed enrollees, especially when it comes to a strap tamper. So in every case, we replaced the monitor. And in fact, in December of 2016, we actually we discontinued our contract with that vendor and engaged a new vendor. So the only point I wanted to make, Your Honor, is that Mr. Thomas was considerably cooperative. One of our rules was we don't go crazy unless you don't respond to us, and he responded to every single phone call. And that makes him unusual in our install base. Most of our install base doesn't respond with that rapidity or with that consistency. So that's the only issue, Your Honor.
Okay. Well, I appreciate you sharing that, and it's good seeing you, Mr. Floto.
Good seeing you too.
And thank you, Your Honor. And what I was trying to show with that is an old adage, what my father used to say to me a long time ago, let him rest in peace, that son, actions speak louder than words. And the actions of Tyler Thomas when he was out on bond for 20.5 months, facing life in prison, maybe with or without possibility of parole, plus a consecutive 5, how he acted during that 20.5 months, Your Honor, to me speaks more loudly than anything that the state or his defense lawyers can say about him as a potential bond candidate. That's reflected in Exhibit 2, Your Honor. Exhibit 2, we requested the Department of Corrections to provide us with Tyler Thomas's disciplinary record history in the time that he spent in the Department of Corrections after being arrested on this murder charge. And they reported offender Thomas does not have any disciplinary record history, Your Honor. It's I'm thinking, I really have a client that's been sitting in prison, in the prison system, pre-trial, post-trial, post-trial, that doesn't have some type of right. A fight over a pack of cigarettes, opening your mouth when you should not have said something, not complying with your curfew requirements, whatever minor infraction is written up, it doesn't have anything. So with that said, Your Honor, I'd then like to bring us to 17-6-1, which you are very familiar with. He poses, the court shall be authorized to release Tyler Thomas on bail if the court finds that Mr. Thomas, 1, poses no significant risk of fleeing from the jurisdiction, failing to appear in court. That has been proven, Your Honor. That has been demonstrated by the 20.5 months he was out on bond. We started trial May 8th, 2017, Monday. He goes home Monday night, doesn't take off. Tuesday, he come back for trial. He goes home Tuesday night. Wednesday, he's in the courtroom. He's hearing Ricardo Thomas tell his story that the Supreme Court had trouble with, which we'll get to in a moment, Your Honor, that Judge Downs had trouble with, that the law has trouble with. He heard it. He heard him tell the jury that Tyler killed Ashley Brown. He went home. He stayed at home. He came back Thursday. He heard the closing argument of Mr. Abadi. Some of the inferences that Mr. Abadi made that the Supreme Court even acknowledged were not correct. Tying him in with the vehicle, with items that weren't even glass, they were plastic. We don't even have to get into that. With other things. He heard it. He comes back Friday. Jury deliberates, finds him guilty. That's it. That was the last time he smelled the outside air. So, poses no risk. Ricardo Thomas, item 2, does he pose a significant threat or danger? Ricardo Thomas was out on the street during the time that Tyler was out. Ricardo Thomas hasn't talked about one threat that was made to him. He didn't even fabricate that may have occurred when Tyler was out on bond. He talked about some supposed threats that happened back in 2013. Tyler told me he's going to put a hit out on me, but nothing when Tyler was released on bond. Number 3, paragraph C, does Tyler pose a significant risk of committing any felony pending trial? His history shows he does not. He didn't do anything, not one petty offense, nothing. No violation, no report written by pretrial of potential violations of any conditions that he had. 4, does it pose a significant risk of intimidating witnesses, otherwise obstructing justice? That has been proven with how he acted with Ricardo Thomas. No claim of any intimidation. So the actions and inactions of Ricardo Thomas, Your Honor, with all due respect, speak louder than what I'm saying and louder than what Mr. Abadi would say regarding the issue of bond. Your Honor, we sent you also character letters that were submitted back in 2014 and 15. If you look at the 7th letter in particular and the last letter in the order that they were sent, they talk about the tremendous love and respect that he has for his father and for his mother. When she unexpectedly was diagnosed with cancer, her battle was short-lived, only 12 months. And that was in 2006, and she passed in 2007. People were writing as to how Tyler, at 18 years old, what he said about his mother at the funeral, how much he loved his mother, the support of his father. Your Honor, we're going to ask that the court allow the bond to be made by the posting of the home. There is no way, Your Honor. You've heard me say this, Your Honor, in the old days when you were with the U.S. Attorney's Office and I was defending cases in federal court. I'm never going to guarantee the appearance of anyone except my two beautiful daughters and my beautiful partner, Miss Judy. But I'm not going to guarantee either that Tyler's going to come. But Your Honor, I feel in my heart he would do nothing to jeopardize his father, nothing to jeopardize the home that the father bought in 1991 that has no mortgage on it. It has a lien on it because Mac Thomas needed money to pay for Eddie Garland and Eddie's firm and Mr. Garland's firm, and to pay for Miss Brandenburg's fee and for my fee, for some of the investigative fees. So he's taken money out. We have about 105,000. I don't have the exact number today, Your Honor. About $105,000 balance on the home. I have Zillow estimates of about $240,000, $248,000 a month ago on a quick sale of the house. We have other homes in that area of the subdivision where the house is 230, 238,000, 250,000, things of that nature. So let's say, Your Honor, let's say the numbers can show you that maybe we have $130,000 equity, Your Honor. I feel that should be able to hopefully satisfy the court of a sufficient bond amount. If necessary, Your Honor, I have Second Chance Bonding Company ready to make a bond. Maybe you can put on a $25,000 corporate surety in addition to the home. And also the conditions that Judge Markle required. Your Honor, I would like to say this to you. I'm fully aware, Your Honor, of the role that you have in determining what type of bond could be appropriate. The gist of the problem that you have, Your Honor, confronting any court and setting the amount of bail is to place an amount high enough to reasonably assure the presence of Tyler Thomas, and at the same time to avoid a figure higher than that reasonably calculated to fulfill this purpose. Your Honor, nothing has changed since the time that Judge Markle put him out on bond. In fact, I think it's even better for him in light of what the Supreme Court said. And I'd like to read that to you, just not all of it, just a couple lines that Tyler Thomas talks to me about every time that he's calling me from jail. And Your Honor, in addition to what I just said about setting the amount of the bond, Your Honor, the American Bar Association's pretrial release standards of criminal justice, standard 10-5.1, presumes that a defendant should be released upon his own recognizance, or if released upon the accused's own recognizance is unwarranted, then the court should impose the least onerous conditions necessary to assume his appearance in court. Now, Your Honor, in our brief, I cited a case that I invariably cite, and I did so in federal court, opposing even you, that the evidence of the guilt or innocence of the person detained normally should not enter prominently in your determination as the judge now, Your Honor, in your determination of whether to grant or deny a bond. However, Your Honor, I'm going to back off from that. And I'm going to say in this case, it should. And the reason why I'm going to say in this case, it should, is because Justice Namias, a unanimous Georgia Supreme Court, wrote in May, on May the 3rd, 2021, that in order for his motion for new trial to, well, this is not Mr. Justice Namias' words, but in getting to the issue of whether the motion for new trial was appropriate, the Supreme Court had to find there was a quote, reasonable probability that the outcome of the proceeding would have been different if the state's deal with Jaleesa Glenn had been disclosed. Tyler says to me, what does that mean? I said, well, look at what the result, the outcome of the initial trial, Tyler, is the jury found you guilty. So the Supreme Court is saying there's a reasonable probability that the jury would have found you not guilty had the state's deal with Jaleesa Glenn been disclosed. A reasonable probability of a different result, according to the Supreme Court, is shown when the state's evidentiary suppression undermines confidence in the outcome of the guilty verdict. And the court says, as outlined above, quote, the evidence of Thomas's guilt came almost entirely from Ricardo's accomplished testimony. And there was much to impeach the story that Ricardo told the jury. And the Supreme Court says, well, he was a convicted felon. He was a drug dealer who connected the victim with Tyler Thomas. He told a false story initially to the lead detective, a story completely different from the events leading to Brown's death and the story that he told during the trial. So then he says that the Supreme Court says, quote, reasonable jurors therefore would have been looking for corroboration of Tyler Thomas's involvement in the murder. And they were instructed in accordance with OCGA section 2414A that such corroboration was required for them to find Thomas guilty. But there was little evidence, all of it circumstantial, to corroborate Ricardo's accomplished testimony. Then the court says what's critical and what is motivating Tyler to want to go to trial, to then be able to be reunited with his family and to have a life beyond incarceration. Supreme Court said the trial court also recognized, quote, Glenn's testimony, that's the girlfriend of Tyler, who.
Your Honor, I'm going to object at this point. This is,
Hold on 1 second.
this is not relevant to the issue of bond. The Supreme Court affirmed that there was sufficient evidence for the conviction.
Okay, I'll let you, I actually have reread the Supreme Court's opinion while we've been working on this because Mr. Weintraub mentioned he was going to be referring to it. So I'm following along. It's on my screen. And I think there are counterpoints to what he's saying that it sounds like you will be making. But I'm going to let Mr. Weintraub promised us he wasn't going to read the whole opinion. So I'm sure he's wrapping up his excerpts from the opinion.
Yes, I am, Your Honor. Thank you. Quite frankly, I'm on the bottom of page 5 from my Google Scholar version of the opinion. The Supreme Court said the trial court also recognized that, quote, Glenn's testimony could be viewed as the most significant piece of corroborating evidence offered by the state in a case where the corroborating evidence was both slight and wholly circumstantial. Supreme Court says, we agree that Glenn's testimony likely played a significant role in the jury's guilty verdicts against Thomas. Despite this significant role, the trial court noted that Glenn, quote, faced no cross-examination regarding her inducements to testify. She wasn't even asked any questions on cross-examination. Supreme Court says this, and I'll end my discussion of the opinion. By contrast, if the state had disclosed its deal with Glenn, Thomas's counsel would have had a powerful tool to undermine Glenn's credibility by showing that she was motivated to implicate Thomas untruthfully by the state. Quite frankly, when they say by the state, they mean ADA Abadi. By ADA Abadi's promise to make her pending felony charge go away. Given Ricardo's, this is the Supreme Court, quote, given Ricardo's shaky credibility and the overall weakness of the corroborating evidence of Thomas's participation in the crimes, there is a reasonable probability that the outcome of the trial, I think the outcome of the trial, Your Honor, was that the jury found guilty. There's a reasonable probability that the guilty verdict would have been different if the juries had heard this impeaching evidence. So if Mr. Abadi thinks this is not probative as to whether or not Tyler Thomas is going to remain confined to the house, should the court grant him a bond. If Mr. Abadi thinks this language is not probative and critical as to any argument he can make or I can make as to what Tyler Thomas will do if released on bond, I strongly disagree with that. So, Your Honor, we ask, it's almost to me, Your Honor, an issue of res judicata. I kind of feel that Mr. Abadi sort of collaterally stopped from even arguing. We filed a motion for a bond pending appeal in September of 2021, September 23rd, 2020, excuse me. No response written by the state, nothing in writing to oppose it. We file another motion for bond July 13th, 4 weeks ago of this year. Haven't heard a word from the state in opposition to a bond being drafted. Federal prosecutors write motions requesting a detention hearing and give reasons why. We haven't had anything in writing. So the first we're going to hear about the opposition is going to be today. It's a serious offense, and we have all this great evidence. Every piece of evidence that they're going to present at this trial, Your Honor, the jury heard, except the geographical locations of Tyler Thomas's phones. They heard about the 33 phone calls between him and Ricardo on the day of the killing. They heard everything. They didn't hear that the main corroborating witness cut a deal. And I think when they hear that, he's going to be set free. So with that said, Your Honor, we ask.
Mr. Weintraub, your computer went on mute right at that critical point. When you said we ask, and I was leaning in and I didn't hear what you asked.
I don't remember what I asked.
I'm guessing you asked for a bond.
We asked for the same bond as posed by Judge Markle. Also take into consideration, Your Honor, we do have medical problems. He's in the medical unit. He's been in the medical unit his whole time, or a good bit of his time. And Ms. Brandenburg, we requested the medical records from the Department of Corrections, and we sent you some highlights. I would like for Ms. Brandenburg to briefly touch upon that. So, Your Honor, we asked for the same $75,000 good bond posed by Judge Markle. And what I was saying, Your Honor, is I really think this is sort of like an issue of res judicata. It's the same parties who were before the court back in 2015. Nothing's changed. Yeah, we had a trial. They found him guilty. They overturned it because the state withheld critical evidence. So now you're going to stand in front of the court and you're going to tell me about the strength of your case? I find that to be so disingenuous, Your Honor.
Well, before you argue about what Mr. Abate says, I'm going to hear what Mr. Abate has to say. But I want to make sure you're able to complete your presentation. So it may be that Ms. Brandenburg has something that she wants to add, and then we'll pivot to the state.
Yes, sir. Just one more minute, Your Honor. I feel this has already been decided. The parties were the same parties. I think the state's collaterally is stopped, especially from their conduct, to argue anything but the same bond that was given. They should consent to that. So Ms. Brandenburg, if you have anything to try to close out what we are arguing, please assist me.
Before we hear from Ms. Brandenburg, though, you've been creative, Mr. Weintraub, as you often are, in importing concepts like res judicata and whatnot. Are you saying that the state consented to the August 2015 bond, or you're saying that they really ought to now consent to it because I guess they haven't filed written opposition to the motions for bond that you filed?
Your Honor, I don't, and Mr. Abadi could correct me, I don't think it was an agreed upon bond. I think they did oppose it. I'm not sure.
Okay, so they're not stopped from changing their mind. I mean, I don't think they are anyway, because there's a guilty verdict out there, but I can't tell from the record. I'm looking at the bond that Judge Markle entered in June of 2015. It doesn't say consented to by the ADA on it. So my guess is that it was the product of yet another bond hearing. There were lots of bond motions filed by Mr. Thomas's attorneys, and one of them finally stuck, I guess. But you're not contending, you're not pointing me to something in the record, Mr. Weintraub, where the state actually signed off on, agreed to, did not oppose the bond that Judge Markle entered in May, I guess June of 2015.
Correct, Your Honor. I'm absolutely am not saying that. And,
okay.
And I did not respectfully intend for the court to think I was even intimating that. What I'm saying is nothing has changed. It's the same circumstances that we had when bond was granted by Judge Markle. So, okay. And that collaterally stopped from, they did not agree to a bond. I'm not saying that, but I'm saying this has already been litigated. And that's why I think the better terminology should have been just res judicata. This has already been decided.
Okay.
And
got it.
Okay. So with that said, I would like the court to allow Ms. Brandenburg to help me out.
All right, Ms. Brandenburg, anything you want to add? We covered a whole bunch.
Yes, briefly, Your Honor. I would just like to discuss the medical records that we submitted as Exhibit 3 that we provided yesterday. Mm-hmm. This is about 6 or 7 pages from about 350 pages medical records that I received from the Department of Corrections based on my request last year. And that's just up to that point in the, I guess, about 2 years at that point that Mr. Thomas had been in the custody of the Department of Corrections. He had generated 350 pages worth of medical records. And as Mr. Weintraub and the court has pointed out, Mr. Thomas is in the medical unit at the jail. So I'd just like to specifically discuss what his issues are. He has asthma and he's on an inhaler for that. That's discussed in the excerpts that were sent. And he is also on 2 medications for high blood pressure, lisinopril and Norvasc, that he requires for high blood pressure. And additionally, he's on a CPAP machine for sleep disorder that's compounded by his asthma. And he has struggled with the jail to be given the opportunity to sleep with a CPAP machine. I think that was just resolved about a week ago for Mr. Thomas. I think these are relevant, not just for the hardship that Mr. Thomas being incarcerated pre-trial at the jail poses, the hardship that he is under, but also to show he's not in any condition to be fleeing the jurisdiction. He needs his medication. He needs his CPAP machine. He is not, in a condition to take to the road and live free and fancy. He's going to be needing to be near a pharmacy, where he can access his medications, as well as, sleep in a regular bed with his CPAP machine every night. I think that shows, that's another factor that shows he's not going to flee. The only other thing that Mr. Weintraub did not touch on was our exhibits, which are Exhibit 4, which are lots of certificates, and mostly from Mr. Thomas's childhood. So we recognize, the temporal issue there, that these are from many years ago. But a lot of these are even from elementary school from Mr. Thomas. And what I really see the value in them, beyond the fact that he graduated high school and played sports and did well in school, was that his father, who provided these to his previous counsel, was in the position where he had kept all of these memories. And I think that shows the close relationship. It's another thing that shows the relationship between Mr. Thomas and his father, whom he will be living with, whom he was living with when he was on bond before and in compliance. Mr. Thomas is both Mr. Thomas and his father are in regular contact with our office, and Mr. Weintraub and I have seen the closeness of that relationship through our representation, the years of our representation, and the concern that Mr. Thomas has for his father and his father's health, where he doesn't even want us to always discuss his own health problems with his father, in order to make sure his father is not unduly stressed when he's going through his own medical issues and now the tragedy of the loss in the family. So the medical issues and the closeness of Mr. Thomas with his father are another additional factors that show that he is not going to flee. He will not put his father in a position where he would be in such a, where he would lose his home essentially from being bonded out. Mr. Mac Thomas, his father, has done everything a father can do to support his son in these trying circumstances. And Mr. Thomas Tyler has done everything that is expected to make sure his father is not more burdened by him having to go through, the circumstances and the charges that he's going to be on trial for here. So we would ask that the court reinstate the $75,000 bond, that there is no reason to think that he would flee or commit any other offenses or be any kind of a bother to any of the witnesses in this case. There's nothing to support any of those contentions. Thank you.
Ms. Brandenburg or Mr. Weintraub, anything, you'll get the final word, but anything else you want to present at this time, or should I turn to Mr. Abate?
I just have to say this, Your Honor, and then maybe we can have the final word. How do I say this? It bothers me more than in any case, I think, that I've ever been involved in. I've been lawyering since 1975. For a prosecutor who was found by the Supreme Court not to have been truthful in representations he made, which representations, which conduct he did and did not do, seemed to have played a role in this human being, Tyler Thomas, being found guilty by the jury. And now this prosecutor is going to stand up and argue that Tyler Thomas should be denied a bond. Yes, I have to tell you that. I've never had that.
You've now told me several times I'm going to tell you that that's not what the Supreme Court found. That's what Judge Downs found, and the Supreme Court accepted those findings. So, of course, the Supreme Court doesn't make independent factual findings. Judge Downs concluded what she did from the record before her, and that is what the record made at the motion for new trial hearing is what led the Supreme Court to get to what it did. But you've made clear your concerns and consternation and outrage and all that about Mr. Abate's purported role in what happened with Ms. Glenn. I'm going to hear from him now, and anyone else from the state side that he thinks is appropriate to weigh in on this question of bond. Mr. Abate.
Yes, Judge, I'm going to make the same arguments that were made at all the other bond hearings in order to avoid any sort of personal attack. But the same issues that were argued during those bond hearings is that there was a fear or that the defendant was a risk of flight because upon his arrest a little over 5 months later on November 18th of 2013 from the incident, he was at a QT gas station when the U.S. Marshals Task Force attempted to arrest him. He got into his vehicle and tried to flee, struck a pedestrian, and his car had to be rammed by the U.S. Marshals vehicles as well as blocked in on all sides in order to arrest him. Upon his arrest, on his person and in his vehicle was found marijuana as well as cocaine, and that is when he was taken into custody for the charges related to this case, Your Honor. The other arguments that were made were that the defendant was a risk of intimidating witnesses. Mr. Weintraub did touch a little bit on this, that from the incident occurred in June of 2013, in between that time in November of 2013, Ricardo Thomas did testify during the trial that the defendant, Tyler Thomas, did approach him.
Are they related or just same last name?
They're cousins.
Cousins, okay.
At a family gathering, Tyler Thomas did approach the witness, Mr. Ricardo Thomas, and tell him that not to say anything about what occurred that night to anyone, and that if he did, that he would put out an SOS, which Ricardo Thomas did testify during the trial, which meant shoot on sight. He took that as a threat. But I will agree with Mr. Weintraub. Since that incident that was testified to, there was no other incidences that occurred between the defendant and Mr. Ricardo Thomas as it pertains to any sort of threats or any sort of intimidation to any other witnesses. There was none found by the state, Your Honor. Those are my arguments from the state. I understand bond is in the full discretion of the court. I would agree with Mr. Weintraub due to the number of bond hearings that it is clear that the state did not consent to any sort of bond when Judge Markle gave it. And I would also bring to the court's attention that had our appellate section done their job, they would have spoken to Ms. Glenn's counsel, and they would have learned that Mr. Ricky Richardson, who was her counsel in Carroll County, he was the one who approached the Carroll County prosecutor and got the dismissal. He wrote an affidavit to that extent at this point, which will be served on defense counsel. But as I testified in the motion for new trial, I had nothing to do with that. I stand by that. I think it's clear that Judge Downs had an issue with me, and she had had an issue with me for quite some time, as well as the elected DA at that time. So that's all the argument from the state. I would bring to the court's attention the victim's family. Mr. Ashley Brown's family would have liked to have been here. His father just had brain surgery, Mr. James Brown, and his mother was just diagnosed with COVID. So they were not able to make the trip down here as they are a little bit older, and the risk of that was too high. Nothing further from the state, Your Honor.
Okay. I know
If I may respond, I'm sorry.
you may in a minute. Ms. Bradley, are you here on behalf of the victim's family?
No, Your Honor.
Are you here on the Monson case?
I'm sorry. I am here on the case that Attorney Besa is representing.
Right? I don't know which case that is, but you're not here for the case we're talking about.
No, sir.
Okay, great. Just want to make sure we touched all the bases. Okay, now, Ms. Brandenburg and or Mr. Weintraub, if you have anything you want to say in rebuttal, I'll point out Mr. Abate spoke for about 3 minutes, so we don't need 20 minutes of rebuttal.
I just want to say this in response actually to what the Supreme Court determined regarding Mr. Abadi's credibility. Very quickly, the Supreme Court writes, Abadi testified as follows, period. This is his testimony. He was put on Thomas's case 4 or 5 days before trial, period. Footnote 16, Supreme Court writes, Abadi's name, however, appears on the notice from the trial court setting, and it goes through all of these pleadings. So maybe the court didn't say it was finding him not to be truthful, but the way I'm reading that seems to me, he said, I started the case 4 days ahead of time, meaning he had little time to offer deals to Ricardo, little time to offer deals to Jaleesa, but yet he's signing pleadings and being served with pleadings 2 or 3 months before trial. Anyhow, okay, that's that.
All right, Ms. Brandenburg?
Yes, Your Honor, I would like to respond directly to what the state has contended in regards to the issue of whether he would flee and bringing up the circumstances of his arrest. It was, as the state noted, that arrest was 5 months after the circumstances in this case, and Mr. Thomas was in no way to know that they were arresting him for a murder charge at that point. The circumstances, of course, are what they were, but he was not aware of that, and I believe that although that was given some small shrift at by Judge Downs as well as the Supreme Court, that there's case law that the timing of the arrest and the circumstances of it do contribute to whether or not that is the probative nature of that in regards to whether or not he would flee. As we've said, he was out on bond and showed that he didn't flee. That's the same as with the claims by Mr. Ricardo Thomas about threats against him. Again, he did nothing while he was on bond to contact Ricardo. And we're aware of witnesses to the interactions between Mr. Thomas and his cousin that was not brought out at trial, but that other family witnesses who were there and heard what happened and would be able to testify as to what they saw in the future. I am interested in what the state has stated about Miss Glenn's attorney, Ricky Richardson. I personally was in contact with Mr. Richardson, and he never told me anything about the way he approached Carroll County. His memory at the time I spoke with him before our motion for new trial, and even on the day of the motion for new trial, were that he didn't have a good memory. So his memory must have changed between now and then and got better somehow, which we all know is uncommon. So we would be interested, of course, in that and seeing that affidavit, but that doesn't comport with conversations I personally had with Mr. Richardson about Miss Glenn's case. So again, we don't think that anything the state has presented negates the record that Mr. Thomas showed while he was on bond, his good behavior while he's been in prison, and his medical hardships that would make fleeing even more difficult for him than it was the first time around. Thank you.
You're welcome. I'm going to focus on Mr. Thomas and not Mr. Abate, because it's Mr. Thomas who's in custody. It's Mr. Thomas that a jury of 12 convicted of murder, and it's Mr. Thomas's liberty interests that we're talking about. I guess where I part ways from what I heard from Mr. Weintraub was this mantra that nothing has changed from the day Judge Markle concluded that a $75,000 good bond was appropriate. Something did change. 12 people who heard the facts and circumstances of the shooting and the death found Mr. Thomas guilty of murder. I appreciate, because I've read now twice the Supreme Court opinion. I've read Judge Downs's order granting the motion for a new trial, that there was potentially information that was not shared with the defense, and that may, and may, of course, is the operative word here. The Supreme Court said nothing more than it may. It has a reasonable likelihood that there could be a different outcome. It might end when Mr. Thomas has his next day in this court, which will be soon. We'll see what a different jury of 12 does with the evidence that's presented. But I think that it's a false logic to say we're back where we were in June of 2015 when Judge Markle set the bond. I'm not going to set a bond at this point, but what I am going to do is set this case down for trial. If we are unable to go forward with the trial because the state is not ready, then Mr. Weintraub, you and Ms. Brandenburg should, it doesn't need to be a long motion, but you should file a motion for bond, and I will set a bond for Mr. Thomas that is along the lines of what you described. But otherwise, I think the right next step is not to give Mr. Thomas a bond, it's to give Mr. Thomas a new trial. That's what he asked for. That's what Judge Downs gave him. And the Supreme Court, upon reviewing Judge Downs' decision, concluded that that was the correct decision, that Mr. Thomas should get a new trial. And we'll see what a jury does when they get whatever the whole picture is. Who knows what Ms. Glenn will testify to this time around, whether she was promised something or not. I'll note that while she did during the hearing on the motion for a new trial say that her testimony was untrue, she declined to elaborate what aspect of her testimony was untrue. She would have been one of at least two witnesses who were told by Mr. Thomas to testify or tell the police or the authorities something other than what they really knew. So I think there is a specter of Mr. Thomas influencing people. I appreciate Mr. Weintraub and Ms. Brandenburg's observation that any of those steps that Mr. Thomas may have taken occurred before he was on bond. But of course, once he's on bond, all eyes were on him. He had an ankle monitor. Mr. Floto's firm was doing what they do very well. And it's a good sign that Mr. Thomas made smart decisions once he was on bond. But I'm not going to ignore the outcome of the trial. I'm mindful of the fact that a new trial was granted. That's why we're all together. And that's what I'm going to do, is get that new trial for Mr. Thomas. So I'm going to ask Ms. Nelson to work with Ms. Brandenburg and Mr. Weintraub and their schedules to figure out when they might be ready to go to trial. And we will set this case down. I'm happy to report that we have trial calendars every 2 weeks now, thanks to some hard work by our jury services group. My first in-person jury trial will start on Monday. And then we move to division specific, meaning Judge Adams, Judge Glanville, Judge Dunaway. We have our own trial calendars, and we reappear on the cycle every 2 weeks. So it will not be difficult to, in the very near term, get Mr. Thomas's case on a trial calendar, not on a plea and arraignment calendar, not on a final plea calendar, but on a calendar where he can have what Judge Downs gave him, which was a new trial. As I said, if that is delayed because I grant the state a continuance because they're having trouble finding witness X or witness Y, along with that continuance will come a bond for Mr. Thomas. Mr. Weintraub, any questions about what I have just said?
No, sir.
Ms. Brandenburg?
No, Your Honor.
Mr. Abate?
No, Your Honor.
All right. I appreciate everyone being here. Mr. Floto, it was great seeing you. Stay healthy.
Thank you.
And Ms. Nelson will be in touch. Thank you. Yes, Mr. Thomas.
I'm still housed with state inmates. So they're waiting to go back to the pre-trial stage again. I'm segregated. I can't be around anyone.
Yeah, we'll fix that. If you're in medical because you need to be in medical, you'll stay there. But I noticed you still got the red jumpsuit, which confuses me. but we'll work with the sheriff's team because you are now pretrial, like you said. You're a Fulton County inmate. You are not a loan out from the Department of Corrections. So if I need to take care of some paperwork to make that happen, I will certainly do that. But what I'm going to have Ms. Nelson do is two things. And I appreciate you flagging that, Mr. Thomas. One is to get with your lawyers about a trial date, and two will be to work with the sheriff's office to figure out what we need to do to have you returned to the pretrial population. Again, that's not going to affect medical status. If you need to be in the medical ward for all the reasons Ms. Brandenburg shared with us, there you will stay, but we ought to get the red outfit off you. Is that what you were asking about? Okay, we'll take care of that. Thank you. Thank you for bringing that up.
Judge, that completes my business. May I be excused?
You may.
Thank you, Judge. Y'all have a nice weekend.
All right, let's please turn to Mr. Salmeron. I believe we have Attorney Webb now. I know we have Ms. Mendez still on the phone. Thank you for staying with us. Mr. Webb, are you there?
I am, Your Honor. Can you see me and hear me?
I can see you. Welcome aboard, sir.
Thank you very much, Judge. It's been a while since I saw you. But this
It
time
has
I think
been. Are you our new full-time conflict defender?
I am, Your Honor.
Excellent. Well, hopefully you'll join us this afternoon because you've got some cases on our upcoming calendar.
I'll be there, Your Honor.
Excellent. Your office has been appointed to represent Mr. Salmeron. Let me make sure I can get him on the screen.
Okay, Your Honor. Let me
North.
see. I need to see you too. There we go.
That's not promising. Let's see here. Here we go. Great. Mr. Salmeron, can you hear me?
Señor Salmeron, ¿me puede oír?
Sí.
Yes.
Great. Your lawyer, Mr. Webb, has joined us.
Su abogado, el señor licenciado Webb, está aquí presente.
Okay.
Okay.
He will come visit you at the jail soon, but today I'm going to ask him a few questions about your case.
Él va a venir pronto a verlo a la cárcel, pero el día de hoy tengo unas cuantas preguntas que hacerle a él.
Okay.
Okay.
Mr. Webb, Mr. Salmeron's case is on our calendar for arraignment.
Señor Webb, el señor Salmeron está aquí en la lista de litigios y comparece para que se haga la lectura de cargos.
My question to you is whether Mr. Salmeron is waiving arraignment and ready to proceed by getting discovery from the state, etc.
La pregunta que tengo para usted, señor Webb, es si el señor Salmeron renuncia a la lectura de cargos y está listo para proseguir para que se le entreguen las pruebas que deben presentarse.
Your Honor, while you were hearing the other case, I went ahead and filed my entry of appearance, and I will go ahead and waive formal arraignment at this time, enter a plea of not guilty, request 10 days to file motions from the date I received discovery, but I will file a discovery motion right away as soon as we finish.
Su señoría, entonces yo ya pude presentar el que voy a fungir como el abogado del señor. En este momento solicito que se renuncie a la lectura formal de los cargos, que me den 10 días para poder presentar la petición necesaria que debo hacer a partir del momento en que me den las pruebas que se han descubierto del caso.
Mr. Webb, the way things work in this courtroom is that you will be given a deadline to file motions that is keyed off of the discovery deadline I give the state. So you'll have more than 10 days. Don't worry about that.
Well, thank you, Your Honor.
Sí,
I'm proud to hear
señor.
that.
Funciona un poco diferente las cosas aquí, pero usted tiene definitivamente más de 10 días para poder solicitar una vez que se le manden las pruebas presentadas. Así que no se preocupe al respecto. Muy bien, gracias, señoría.
Mr. Webb, I'm going to have Ms. Nelson email you a waiver of arraignment form that
Yes,
I'll
sir.
ask you to complete on behalf of your client and send back to her.
Yes, sir, I will.
Le voy a enviar a la señorita Nelson, señor Webb, el documento de la renuncia a la lectura de cargos para que usted la firme y se la envíe de vuelta. Sí, está bien. De parte de su cliente, lo va a firmar él.
Mr. Salmeron, your lawyer, Mr. Webb, will be in touch with you soon to talk about your case, okay?
Señor Salmeron, el señor Webb va a estar en contacto con usted pronto para hablar sobre su caso. ¿Está bien?
Sí, gracias, muy amable.
Yes, thank you. You're very kind.
Should Mr. Webb have with him an interpreter to speak with you?
El señor Webb deberá tener una intérprete para poder hablar con usted.
Sí, por favor.
Yes, please. Yes, I would really appreciate that.
Okay, Mr. Webb, is that something you're able to do?
Señor
We'll
Webb,
have to find out, Your Honor. This is only my 5th day on the job, so I'm just getting my sea legs here. But it seems to me like that we probably have mechanism for that.
Señor Webb, usted puede hacer que eso suceda. No sé, es mi 5º día en el trabajo, no estoy seguro, pero voy a hacer lo posible para que eso suceda.
Great. Well, if you need help with that, Mr. Webb, please reach out to Ms. Nelson and we'll see what we can do.
I will, Your Honor.
Si necesita ayuda con eso, señor Webb, por favor comuníquese con la señorita Nelson y ella le indicará cómo lo puede hacer. Así lo haré. Gracias.
That is all. Thank you, Mr. Salmeron.
Eso es todo. Gracias, señor Salmeron.
Gracias al juez y a mi licenciado y a usted, señorita. Muy amable, gracias.
Thank you to the judge, to my attorney, and to you, ma'am, for assisting today.
One last thing I forgot to ask. Ms. Beza, is this your case?
No, Your Honor, it's my case.
Oh, right. It's yours, Ms. Patel. Anything you want to add while we have our interpreter here?
No, Your Honor, I'll just make sure the discovery gets served.
Algo más, señorita Patel, es su caso. Sí, estoy aquí. Algo que quiera agregar, no. Nada más voy a estar al tanto de que se den las pruebas que se han presentado en el caso.
Great. Thank you, everyone.
Gracias a todos.
Thank you, Your Honor. May I have Ms. Patel's email address, please?
I'll send it
you
to the chat.
Send it through the chat. I'm sorry. Thank you, Your Honor.
Okay. Thank you, Ms. Mendez. I don't know how we sign paperwork for you, but we'll take care of it.
Yes, thank you, Your Honor. I appreciate it.
Okay. Mr. Salmeron, you can go now.
I'll see you at 1 o'clock, Your Honor.
All right. Sounds good.
Thank you.
So that should get us to Mr. Burns' client, Mr. Monson, who is in 5 South, maybe? Mr. Monson, are you there?
He's waving his hand, Your Honor.
Good. All right. I will activate the microphone there. Give me a second. 5 South.
May I be excused, Your Honor?
Yes, sir. We'll see you at 1.
Okay, thank you, sir.
All right. Mr. Monson, can you hear me?
Yes, sir. I hear you. Right. Yes.
Pardon me?
Yes, sir. I can hear you.
Great. All right. Well, we're going to go on the record in your case. This is 19 SC 171997, State versus Corwin Monson. This is a case assigned to Judge Ellerby. Mr. Byrne filed a motion to recuse Judge Ellerby. She reviewed those pleadings and determined that the case should be temporarily randomly reassigned to another judge to consider the motion to recuse. I was the judge who randomly received it. And we're going to talk this morning about Mr. Burns' motion to recuse. Ms. Mack, are you representing the state?
I am. Good morning, Judge.
Good morning. Good to see you.
Too.
So, Mr. Byrne, I have your motion. I've read it, and I am happy to hear from you if this is something that you are still pursuing.
Yes, Your Honor. Good morning. And yes, this is something that I am still pursuing. For the purpose of today's hearing, we are just going to rely solely upon the affidavits. We do not expect that we will convene an evidentiary hearing as Rule 25.6 of the Uniform Superior Court rules permit and allow. Insofar as the affidavit is concerned, the issue, I believe, before the court, for Your Honor, is whether if the affidavit is sufficient and the facts set forth in the affidavit are true, then the court, Your Honor, should reassign this case to a different trial judge.
Oh, well, now pause there for a sec. Doesn't there need to be the ultimate finding that the facts, if true, justify reassignment? You could put in an affidavit, it rained on August 19th in Atlanta, and you could prove to me that's true, or I could take judicial notice of the fact that I was wet. I got rained on when I was walking my dogs yesterday. That's not a basis for recusal. So it's not just that you can prove, or maybe the state stipulates that Judge Ellerby declined to grant a continuance when Mr. Monson brought on yet another lawyer, this time on the eve of trial. Doesn't it have to be that the facts alleged in the indictment justify recusal? Because otherwise you could recuse a judge just by filing a truthful affidavit. And I think your affidavit was truthful. I think what we need to work through is that a basis to recuse a judge because a judge did not grant a continuance to a lawyer who was retained at the 11th hour before a trial. But if I'm missing the analysis, if you think, no, Judge, that's the wrong, if you think the facts are true, you must recuse, I'll roll with you for the purposes of this hearing. I just think you're going to be disappointed because I don't think that's what the case law or the uniform rules say.
Well, I agree with you in that Your Honor still needs to make a finding that, assuming and finding as a matter of fact that my affidavit is true, that recusal is the appropriate resolution.
Okay.
But I disagree with you in terms of the basis for the motion to recuse. I will say that the motion for continuance is a part of the series of events that occurred, and basically the first event that occurred that ultimately brought about this motion, but it is certainly not the only one, and it is certainly not the only reason that the court could find and make a conclusion of law that that recusal is the appropriate resolution. So
I don't disagree with that, and I was simplifying the affidavit. It's 9 paragraphs, so it's not particularly long. But why don't you share with me why you think what's in the affidavit is accurate, and if accurate, is a basis for recusal?
Well, I'll say very simply that the affidavit is accurate. I don't think there's going to be even a disagreement from the state that my affidavit is true, is truthful. I was hired at the 11th hour by Mr. Monson to represent him for trial and any other purposes up through including any motions prior to trial. I filed my motion for continuance based on the fact that I had been recently hired, and the state did not object at the pretrial conference. The judge certainly considered the arguments and denied and overruled my motion. The fact is that additional information came to my attention as I was preparing for trial, including having to file voir dire and request to charge by a certain deadline. That was Friday afternoon before Monday's trial date. It came to my attention that there was a plea agreement which was worked out between Mr. Monson's first attorney and the district attorney of Fulton County. And that explains why I was hired at the 11th hour, because the attorney who was representing Mr. Monson before me was not the attorney who negotiated the plea agreement, but was another attorney who did not raise and did not file a motion to enforce the plea or to schedule the plea at all. So when I discovered this fact and was confirmed by one of the persons involved in the negotiations, I filed my motion to enforce the plea agreement.
Which Judge Ellerby denied.
And this is the problem, because what happened is she denied it because of its untimeliness of being filed, which, if you look at her order where she denied the motion, which was filed on July 12th, 2021 at 12:18 a.m. It was denied as untimely and in violation of her case-specific scheduling order, which I sent to Your Honor in an email a couple days ago, which, referring back to that scheduling order, it says that, and this is on page 3, the title is Motions and it's paragraph 1. Motions filed after the due date for all motions are untimely and will, capital letters, not be considered absent a showing of just cause for the late filing. Judge Ellerby's order did not address the reason and cause for the late filing, which I made in my motion to enforce the plea. I basically acknowledged that it was a late timing, but I had just cause for it. And interestingly, I pulled up Your Honor's scheduling order.
And that is relevant in what way?
In that it's different, in that it is more detailed, and that it gives the judges and lawyers more direction on what to do in these events. And
okay.
Your order is much more detailed. It gives attorneys, and it gives, I think, yourself a lot more, a better understanding of what is expected of all people involved. Judge Ellerby's order, scheduling order, is basically it's more simple, but her order didn't address the order denying my motion to enforce a plea never addressed the just cause. So that motion is denied, and now we're sitting here on Monday of trial. I have followed the court's orders in filing voir dire and request to charge. I'm certainly not ready for trial, though. I I haven't reviewed the evidence. And in fact, I have another trial scheduled in federal court a week and a half or later that week.
So this is not in your affidavit. So are you testifying now? Is this new evidence you want me to consider, or what are we doing now?
This is in my motion to continue. I have it in my motion to continue.
That
My
you,
initial motion to continue should have. Yes. On my last paragraph, my second last paragraph is that I had a conflict later that week.
that I'm aware of, but you just told me you filed voir dire and you filed this and that. And is that in your motion to continue?
It's not in my motion to continue. There's a record of it because it's filed.
Okay, but I just want us to stay focused, which is, does the affidavit justify recusal? And the affidavit doesn't talk about whether you filed voir dire or not. And so I want to work with what you've asked me to work with, which is the affidavit. And you contend that what's in the affidavit is accurate. I think you're right. Of course, Ms. Mack will get to weigh in on that, but I'm not real focused on that. I'm trying to suss out of the affidavit what would justify the recusal of a judge, because that's asking a lot. That is saying that a judge has some bias, some prejudice, something that arises from something other than what the judge has learned about the facts of the case and making rulings and whatnot, that she should be recused. It's a pretty powerful tool, and we don't want to allow for judge shopping or anything like that. So I want us to stick to the affidavit. And what I've heard so far is Judge Ellerby's denial of your motion to enforce as untimely is indicative of something, because she didn't address what you contend was your explanation of just cause for the late filing.
That's right. That's one ground. The second ground basically is what happened on the Monday of the final meeting of the parties before trial commenced. And this is addressed in my affidavit.
Okay, let's turn to that.
That there was another case that, let me go back. There were three cases that were brought in for trial. There was a case that was, I believe, a murder case that had already, they were in the big courtroom or wherever they were going to conduct voir dire. They were there, they were ready to start. Then there was Mr. Munson's case was the second oldest case. And then there was a case after Mr. Munson's case, which I believe was a sexual abuse case or some sort of maybe a statutory rape case, but something that it was sex crimes case that was actually pre-tried before Mr. Munson's case on Monday morning. Those parties announced ready. Those parties were ready for trial. Then it was our turn, and I renewed my motions to continue. They were denied. And basically we're standing and waiting to see what would happen to that first case. If that first case had not gone to trial for whatever reason, Judge Ellerby made it clear that Mr. Munson's case was the next case that was going to be tried. Well, I realized as counsel that I would have to make a decision if I was the next attorney up and Mr. Munson was the next defendant up, of whether we would in fact consent and agree to go to trial voluntarily. That put me in a very uncomfortable and difficult place to be, and Mr. Munson too, because he and I mean, his decision would have to be made of whether I would basically say no to a court order, which would put me in direct violation of the judge's ruling and would subject me to a contempt of court. It was very dramatic and could have been traumatic to me and to Mr. Munson. And that what makes it most troublesome is that there was another case ready to be tried that had announced ready, that the parties were not under that same pressure that Judge Ellerby had put myself and Mr. Munson in. And that was basically the tipping point to me, that Judge Ellerby, while having the right to make the decisions she did, exercised her discretion in a way which I believe knowingly put me in danger of my liberty, and Mr. Munson in danger of having to go to trial without an attorney who was prepared. That could have been avoided, but it wasn't. And by the grace of God, that first case went to trial. And I did not have to make that Hobson's choice. I don't believe that Judge Ellerby can be fair, and I believe under the judicial canons of judicial ethics, that she has placed the case in a way that she has personal bias or prejudice concerning a party, which can be inferred. And I sent you the case of Baptiste versus State, 229 Georgia Appeals 691. It's a 1997 case. And it says that impartiality might reasonably be questioned. What that means is, because the Code of Judicial Conduct, Canon 3E, says that judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. Impartiality might be reasonably questioned means a reasonable perception or lack of impartiality by the judge held by a fair-minded and impartial person based upon objective fact or reasonable inference. There doesn't have to be any actual impropriety on the part of the trial court judge, but it is the inference that can be made. And I could think of no other inference that could be made by Judge Ellerby's order, which didn't address good cause for the out-of-time filing of the motion to enforce the plea agreement, and her unwillingness to continue the case when there was another case ready for trial. And knowing what the dilemma would be to me and Mr. Munson.
Isn't the dilemma, though, one of Mr. Munson's own doing? Here, it's just something I'm grappling with, and I'm sure you've thought about this, so I'm interested in hearing your response. No one forced Mr. Munson to hire a new attorney on the eve of trial. Mr. Munson, it is not your turn to talk, okay? Mr. Byrne, hopefully you came in with eyes wide open. If Mr. Munson didn't tell you, by the way, we're on Judge Ellerby's trial calendar right around the corner. Shame on Mr. Munson. But assuming you knew, Mr. Byrne, you also should know that it is not a judge's problem. It is not the opposing side's problem if a defendant who is retaining his lawyers switches lawyers on the eve of trial. It's complicated for you. I don't doubt that at all. It's complicated for you. Maybe you charge more coming in this late, but to accept a client on the eve of trial and then blame the judge for saying, you know what, I'm not going to continue this case. There are interests beyond just Mr. Munson. There's an alleged victim in this case. There's the public's interest in speedy trials, et cetera. So where I'm struggling a bit is not the end of your analysis, but the starting point that how dare a judge think that a continuance shouldn't be effectively automatic because a defendant brings in a new lawyer at the 11th and a half hour. Walk me through that part.
I don't think it should be automatic. I think that you need to look at the case as you do every time. You have got to look at a case individually. Number one, you have to see what has occurred prior. Has the case been on a trial calendar before? Has it been continued before? You have to look to see if there's opposition from the opposing counsel of whether a motion to continue should be granted. You also need to look at whether the defendant is in custody or not. And Judge Ellerby did make the comment that Mr. Munson has been in custody for several months, to which Mr. Munson specifically waived his, and understood that, and waived his interest in having a trial the following week. And you look at whether there are other cases that can be tried and not hold up the entire calendar so that nothing is getting done. So there are a lot of factors. And I agree that you don't want to set a precedent that just because a lawyer gets hired at the 11th hour, they file a motion to continue because they've got a conflict or they're not ready, whatever it is. That doesn't get you there. But when you add the other facts, and these are not allegations, these are facts. The other facts in the case, it does support the granting of the motion to continue. And that is what should have happened here. And then you couple that, you add to it this motion for enforce a plea agreement, which would resolve the whole case. In fact, it would resolve everything related to Mr. Munson being in custody. That's that's a big motion. That's not a frivolous motion. That's not an out-of-time motion to suppress evidence or a motion for an alibi witness or something like that. This is a case solver. To deny it without any recognition of any reason for good cause or making an analysis of it, like Your Honor does in your scheduling order, it's troublesome. And it caused me to do what I did. I will conclude with this. I know Mr. Weintraub, I heard his story that in all these years, this and that. I'll say that I've never.
We don't have that many years, but I hear you.
A lot of years, a lot more than you and me.
Yeah.
I don't believe I've ever filed a motion to recuse a judge before. Because I have a great respect for the robe. And you know that. You know my reputation. And I don't do this lightly. But what Judge Ellerby has done is prevented Mr. Munson from having what we would argue is a plea agreement enforced. Because I have no other recourse. Because of her order. The only way we get to have this issue fleshed out is to either have her reconsider her motion denying the motion as untimely, or to have the case reassigned to a different judge so that we can then file the motion, not have it be rejected as untimely, and see if this is what should be. I mean, this is Mr. Munson's case. Ultimately, it's his due process rights. I understand my feelings were hurt when I got put in a really difficult place, but ultimately this is about Mr. Munson. And if I think that he and the district attorney have entered into a plea agreement, by gosh, that should be heard. That's his due process rights. And what's interesting is there is case law that talks about enforcing a plea agreement when the administration has changed. So there is actually support for enforcing this plea agreement, even though all the parties are different in terms of that made this agreement. And I refer the court to the case of Sims, SYMS versus the state, which is 331 Georgia Appeals 225. It's a 2015 case. So yes, it is a big deal. I know it is. That's why I've never done it before. But I think that for Mr. Munson, it is the appropriate way to resolve this. And that's all I've got to say. Thank you, Your Honor.
You're welcome. Thank you. Ms. Mack, good morning.
Good morning.
So I am interested in hearing your perspective, but I'm going to start with a question. Do you know, have you been the lawyer on this case for how long?
Since probably, I'm losing track of time. I got to the office in March. So,
okay. Well, but that's fine. My question is, were you the lawyer on the case when Judge Ellerby was calling it for trial in July?
Yes.
So Mr. Byrne asked for a continuance. Judge Ellerby denied that continuance. My question is, did you state a position to Judge Ellerby on the continuance? We don't oppose it, we do oppose it, or that's your decision, Judge Ellerby? What did the state have to say about Mr. Byrne's motion for continuance?
The state didn't oppose it.
Okay, does that mean you said nothing, or?
It means I said when she asked the state, what is your position? The state then replied, the state does not oppose.
Okay, that answers my question. Now I'd like to hear anything you want to say. You may have nothing to add. It's not a, this is a really about the judge, not about the state. But if there are things you want to have heard about the motion to recuse, now is the time for them to be said.
Judge, as you stated, I was pretty much here as a spectator. Just because the state is not our motion, we don't have a position on whether he's reached his burden. As far as the affidavit, the only thing that I would add, and I know the judge really didn't deal with the issue of enforcing the deal, because that's not really what it's about. It's really about whether Judge Ellerby should keep the case. I would just point out in subsection 6, and that's pretty much where Mr. Byrne lays out what he believes to be what occurred as far as enforcing the deal. I would just say the state is not, what word am I looking for? Confirming that. I mean, he's saying that is what his, the information he's received perhaps from his client or perhaps from a witness, a part of that. The state is not saying that there was a deal that was in place. Now, whether he has a right, to have that litigated, obviously is a different issue. But the state's position wouldn't be, oh, there was a deal and it just needs to be enforced. But I think Mr. Byrne's position was, he thinks it was, and he just thinks it should be litigated, is from what I understand.
I do too. I don't think I need to reach the issue of was there a deal or not. That's not what's before me.
Right.
Maybe someday if Judge Ellerby is recused and it lands with me. Mr. Byrne's observation and argument is the motion ought to have been heard, and the way in which it was denied is implicit evidence that Judge Ellerby, this is Mr. Byrne's argument. I'm not saying this is my finding as this record is being made. Mr. Byrne's argument is that the judge's denial of the motion as untimely and not addressing the substantive grounds is implicit evidence that Judge Ellerby has some partiality here and isn't being the neutral and detached magistrate that judges are supposed to be in situations like this. And that's how I understand the argument. And so I don't intend to wade into, was there in fact a plea agreement or not? Who knows? Maybe, maybe not. That question really never got answered because the motion was denied, as Mr. Byrne put it, on procedural grounds rather than substantive grounds. Was there anything more you wanted to add, Ms. Mack?
No, Judge, I think that because I was similarly situated with Mr. Byrne, I wasn't familiar with Judge Ellerby. I hadn't been in front of her before. So there's no way I can kind of weigh in on what she typically does, you know, or if she's done it for other cases. It's just no way for me to know. So this was just my experience, first experience with her. And so the state really doesn't first experience with her scheduling order. We just really didn't have a position on whether whether the actions that she took showed any type of bias or prejudice against this particular defendant.
All right, thank you. So Mr. Byrne, your motion, I'll give you the last word, although Ms. Mack didn't really say anything that justifies much of a rebuttal. I think she's taken the approach of this isn't our fight. I guess I want to get this clear on the record though, Ms. Mack, before I turn back to Mr. Byrne. The state is not joining in this motion. The state is not seeking Judge Ellerby's recusal. Is that correct?
That's correct. We're
Okay.
not joining in this motion.
Got it. Mr. Byrne.
Judge Marvin Shube taught me a long time ago, when you've said what you want to say, don't say anything else. So I don't have any rebuttal.
A very wise man, Judge Shube, that is, and you're wise to follow his words. It's hard to do that sometimes. Like, you know what, I'm going to just say one more thing. And sometimes that causes the lights to go out. So quit while you feel like you're ahead. All right. I appreciate, Mr. Byrne, your cogent and focused arguments. I have your pleadings, and I will take them under advisement. I will get an order issued soon because I know Mr. Monson's case is just hanging out there until then. Obviously, there are two outcomes. One would be that I deny the motion and the case returns to Judge Ellerby. And I assume it will return to a trial calendar and you all will navigate that as you see fit. If I grant the motion, it does not become my case, just so we're clear. It might, but that would be purely random. The universe of judges to which Mr. Monson's case could go is a little smaller because I believe there has been at least one other recusal. I think Judge Dunaway has made clear this is not a case that he can have. He didn't give a reason for it, but he did recuse. So it will nonetheless be a random reassignment, should it be reassigned. But there would be at least one judge who's not in that universe of potential assignees. Mr. Byrne, anything else before we wrap up?
No, thank you, Judge.
Ms. Mack? Nope.
Nothing from the state, Judge.
All right. Well, thank you everyone for your time. I will turn to this as soon as I can and we'll keep it moving along. And I believe that completes the calendar. So Lieutenant Barry and your team, thank you so much for working with us with our technical issues. We will make sure that the Zoom booth controller is ready and running at the start of each of these calendars rather than about halfway through. That would have saved us about 30 minutes today, but we took care of what we needed to. And with that, I will end the